Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of civil procedure, especially matters involving the bar on civil court jurisdiction under section 34 of the SARFAESI Act shall be applicable only in a case where the Debt Recovery Tribunal and or Appellate Tribunal is empowered to decide the matter under the SARFAESI Act. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Leelamma Mathew versus Indian Overseas Bank and others, pronounced on 17th November 2022, the defendant bank secured the disputed property in exercise of powers under the provisions of SARFAESI Act. The bank took the possession of the property pursuant to the order passed by the CJM in an application under Section 14 of the SARFAESI Act. Thereafter, the plaintiff, who was ready and willing for purchase of the property, paid a total sale consideration for the same. But the Tahsildar submitted the report stating that the actual measurement of the land is 99.60 cents and the debtor already transferred 14.40 cents out of land measuring 54 cents prior to the creation of the mortgage. Despite the above, the bank issued the sale certificate for 54 cents and handed over the possession of the secured property measuring 39.60 cents. Only, however, the sale consideration is issued for 54 cents. Thereafter, the sale deed on the basis of the sale certificate was actually executed in favor of the plaintiff. Thus, the plaintiff instituted the suit for recovery of damages or compensation with respect to 14.40 cents. The trial court decreed the suit. On appeal, the Kerala High Court quashed and set aside the decree passed by the trial court and dismissed the suit. Being agreed, the present appeal has been filed with the issues posed for consideration, and they are whether suit barred by limitation and Section 34 of SARFAESI Act. The Supreme Court has held that the bank took the possession of the property auctioned on paper. However, the actual possession was handed over to the bank in pursuant to the order passed by the CJM. Thereafter, the Tahsildar submitted the disputed report. Despite the above, the bank issued the sale certificate for 54 cents, however, handed over the possession of the secured property measuring 39.60 cents only. The sale consideration received by the bank was for 54 cents. The sale certificate was registered in the month of October 2010. Thereafter, the plaintiff filed the suit for recovery of damages with respect to 14.40 cents. The final certificate was registered on 1/10/2010, and thereafter the suit was filed in the year 2012. So, it cannot be said that the suit was barred by limitation. No issue was framed by the trial court on whether the suit is barred by limitation. The suit was for damages or compensation with respect to the balance land which could not have been decided by the DRT or Appellate Tribunal. Section 34 of the SARFAESI Act shall be applicable only in a case where the Debt Recovery Tribunal and or Appellate Tribunal is empowered to decide the matter under the SARFAESI Act. The plaintiff was not challenging the sale or sale certificate. The plaintiff claimed the damages or compensation with respect to the lessee area. Therefore, the High Court erred in holding that the suit was barred by Section 34 of the SARFAESI Act. Further, right from the very beginning, the plaintiff insisted for handing over the possession of the 54 cents. When the property was put to auction, even the bank was not in actual possession. The bank got possession pursuant to the order passed by the district magistrate, and thereafter the measurement was done by Tahsildar, in which it was found that the actual area of land auctioned was 34.60 cents and 14.40 cents was already transferred by the debtor much earlier. Therefore, at the relevant time when the property was put to auction, even the bank was not aware of the actual measurement and went by the document, and 54 cents was put to auction. Considering the fact that the auction notice was for 54 cents, the plaintiff submitted the offer of rupees 32,05,000 for 54 cents. The plaintiff paid the actual amount of sale consideration, that is rupees 32,05,000 for 54 cents. The sale certificate was issued for 54 cents. Thereafter, it was not open for the bank to contend that though the bank handed over the possession of 34.60 cents, still the sale consideration recovered would be for 54 cents. It was not open for the financial institution like the bank to take such a plea. Even otherwise, it is required to be noted that at least in the month of November 2007, when the Tahsildar submitted the report, the bank was aware that the actual area is 34.60 cents and not 54 cents. Thereafter, the bank ought not to have issued the sale certificate for 54 cents. The bank ought to have been fair and ought to have issued the sale certificate only for 34.60 cents. This shows the contact on the part of the bank. Rule 8 of the Security Interest Enforcement Rules 2002 caused a duty on the authorized officer to take all precautions before putting the secured asset to sale. As per Sub-Rule 5 of Rule 8, before effecting sale of the secured assets, the authorized officer shall obtain valuation of the property from an approved valuer and in consultation with the secure creditor and fix the reserve price of the property and may sell the whole or any part of such immovable secured asset. Therefore, when the reserve price was fixed, the same was for 54 cents. Therefore, it can be presumed that the bank was aware that the actual area of the secured asset is less than 54 cents. As per Section 54 of the Transfer of Property Act, the seller was bound to disclose any buyer any material defect in the property of which the buyer is not aware and which the buyer could not ordinarily discover. Under the circumstances also, the submission on behalf of the bank that the property was put to auction on as is, where is, and as is what is condition. Thereafter, the plaintiff shall not be entitled to compensation of the less area cannot be accepted. The High Court erred in allowing the appeal and quashing and set asiding the decree passed by the trial court. Consequently, the judgment, that is the impugned judgment and order passed by the High Court is hereby quashed and set aside. The judgment and decree passed by the trial court decreeing the suit is hereby restored. The bank to pay the decretal amount to the appellant with interest as per the decree passed by the trial court within a period of 8 weeks from today.